This is a fifth lectures on equity. In the first lecture, we have seen the importance of equity. And also we have seen the equity is the base for the law of trusts. That's why, first of all, we must study the equity and understand the equity. Then we will study the law of trust. The term of equity is associated with the notions of fairness, morality, and justice. But as you know, the equity cannot be equated to justice. But the equitable principles may be applied to find the justice in a given problem. And also we have seen that the equity assists to reform the rigors and hardness of the common law. And also equity assists the law where it is defective or weak. In addition to that, we have seen in the first lecture that relating to conscience of the chancellor. What is known as conscience? That's very difficult term. Conscience is little bit difficult to define. First of all, we have seen the conscience in the sense if anybody made an application or the petition to the king determined the dispute in accordance with his conscience. And thereafter, chancellor started using the same conscience. And once the chancellor was a keeper to the conscience of the king, and thereafter we have seen that even the chancellor was to judge the people conscience to determine the issues and problems or disputes. That's the main topic that we have seen in the first lectures, and thereafter in the second lectures we have seen what is known as common law. That's very interesting that we have seen like after Norman invasion of these England, all these areas brought under one rule. Then the common law, the law was common to all United Kingdom that we have seen, and thereafter we have seen the acts of 1873 and 75, and we have seen whether there is a fusion of administration of law and equity or fusion of law and equity. We have seen so many authorities to support that there was a fusion of administration of law and equity. But we have seen certain authorities in relation to the fusion of law and equity. That we have done on second lectures, and thereafter we have seen what is known as equitable rights. Then what's the nature of the equitable rights? And we have seen the equitable remedies also. In that one we have seen that right in rem and right in personam. Right in rem in the sense there is a particular rights in relation to the property. Right in personam in the sense it is a right against a specific person. That we have seen very in detail, that we have seen all these things. And common law remedies that we have seen, as well as we have seen equitable remedies. Generally, common law remedies, we can see the damages. But in the case of equitable remedies, we have seen specific performance, injunction, rescission, and also rectification that we have seen. Today, we are going to see the maxims of equity. Now, the maxims of equity are the fundamental principles which were worked out by the Court of Chancery and provide general guidelines to judge as to when to exercise their equitable jurisdiction. We must keep it in our mind that this is the maxims of equity are guidelines, not like law. Because guideline in the sense, this is something helping to the judges to find the justice. That's a general guideline to judge as to when to exercise their equitable jurisdiction. They reflect the equity's general approach to the solution of legal problems. The maxims of the equity embodied in general principles which evolved in the Court of Chancery. They are not rules. If you say that they are rules or if you say that they are laws, then you should follow as it is. But these are guidelines. They will guide to find the equitable remedy or even justice. There are number of maxims given here, but about 12 maxims given here, but we will see, first of all, we will see one by one. Some are very interesting and useful and also examinable. Or sometimes there may be a general question on maxims also. Now here, this maxim, that says equity will not suffer a wrong to be without remedy. This maxim is not to be taken too literally as equitable remedies. The equitable remedies are geared only to strike against unconscionable behavior and to operate only if that behavior constitutes a legal wrongdoing. The underlying rationale of this rule is that equity will strive to interfere in order to remedy a legal wrong when the common law is inadequate to do so. Then here we must see that when the common law is inadequate to give some sort of remedy for that legal wrong, the equity will take all necessary steps to interfere in order to remedy the legal wrong. In other words, equity will attempt to ensure that deserving claimants obtain redress or relief. A broad-based illustration is the law of trust, under which the beneficiary has no remedy at common law. No remedy at common law. And here we are seeing, what we are studying here, the broad-based illustration is the law of trust under which beneficiary has no remedy at common law. What is that? Because who is the legal owner? The trustee is the legal owner. When you go to the common law will say legal owner has full power to do whatever he wants. That's why here we say that beneficiary has no remedy at common law. In the eyes of the common law, it is the trustee who has the legal ownership of the trust property and not the beneficiary. That we have seen several times in several circumstances in previous lectures. The beneficiary could enforce his beneficial interest in equity. That's important. Then if as a beneficiary, if you want to enforce his beneficial interest, then he must enforce it in equity. A more specific example concerns injunctions which we can employ to prevent an anticipated wrong, whereas there is no remedy at common law until the wrongful act has been performed. Suppose in common law, if there is no wrong committed, you can't go and file an action. If there is a law, law prevents certain acts. If a person commits such action or act, then only we can go to the court. That's why here we are saying more specific example concerns injunction which can be employed to prevent the anticipated wrong, whereas there is no remedy at common law, because until the wrongful act has been performed. Then the first of all, there must be a wrongful act. Then only we can perform. We can go for a court. Then here the classic example is the enforcement of law trusts. The beneficiary had no remedy at common law if the trustee claimed the property for himself, as trustee was the legal owner, but he could not enforce his right in equity. But there are limitations to this maxim. First of all, there are two limitations given. Then the first one we can see where the right and remedy both within the jurisdiction of common law. The right also within the jurisdiction of common law, remedy also within the common law, then you can't get this, you can't get the assistance of this maxim. Then the acts of state, court are not authorized to question the acts of state. Then we will move to the other one, the following slide here. A beneficiary has no right at common law to have the terms of trust enforced. Then how we are doing that one? Then the issue here, in equity, he has the right in equity. But the court will require the trustee to carry out those terms to prevent him committing what would be in effect a wrong against beneficiary. Then we will move to other one that's known as other maxim that's known as equity follows the law. The general rule is that equity will adhere to the common law unless there is some exceptional justification for not doing so. Generally, the general rule is that equity will adhere to the common law. Until otherwise there is exceptional justification, they must follow the common law. The equity always should be with the common law or subject to the common law. But there are some exceptional circumstances, then there must be exceptional justification, then the equity may deviate from the common law. If possible, equity will harmonize its own rule with those of common law. Then there are circumstances, and also if it is possible, equity will harmonize its own rule, the equitable rule or equitable principle with those common law principles or common law. An illustration of this maxim concerns the refusal of equity to contradict the common law rule that a third party cannot be made to perform a contract. Generally, the parties to the contract must perform the obligations under contract. The third party cannot be made to perform the contract. Hence, the general rule is that specific performance is available only against a party to the contract. That is, the equity always follows the law. Now, the next slide we will see here, the court of common law and the court of equity came to completely different decision on the merits of the very same case. The common law courts applies rules mechanically. Equity enables fairness and principle to outweigh the rigid rules. Therefore, equity will have the priority over the non-statutory common law. If there is a statutory common law, if there is a common law, then equity should go with that. But if there is a non-statutory common law, then equity will have the priority over the such non-statutory common law rules. Now we will see two cases here. If an interest in land does not satisfy the basic requirement for its existence, then it will not exist as interest in the land either at law or in equity. Likewise, other example here, where a legal title to the land is held jointly, equitable interest follow the legal title unless a contrary intention is proved. Then, where the legal title to the land held jointly, then the equitable interest also must be shared equally or jointly, unless contrary intention is proved. Then we will move to the next maxim. He who seeks equity must do equity. A claimant who seeks the relief of equity must himself be willing to act fairly towards other party. It's a very interesting point here. The claimant, if you go for a case, if you file a case, you must be able to act fairly towards other party. Some extent we can say there must be a give and take policy. The claimant who seeks the relief of equity must himself be willing to act fairly towards other party. A person seeks equity must be prepared to do equity. Because if I go for equity, I must be prepared to do equity. That's very important and very basic thing in normal human life. Then we will see, for example, a person seeking the grant of an injunction or the specific performance must be willing and able to perform his own future obligations. Similarly, if the claimant seeks to rescind future obligations, if the claimant seeks to rescind a contract, the court will ensure that claimant acts equitably by returning any deposit paid under that contract. Now, as a person or as a party to the contract, you go and ask the court to rescind such contract. Then what you should do is, you must be ready to return whatever deposit made under such contract, because you who seek equity must do equity. The key consideration is that the claimant must be prepared to act fairly towards the defendant. If the claimant cannot or will not perform his obligation, court will not grant equitable remedy. Now, if you go, there's a party to the contract, then you go and ask to issue a specific performance of an obligation under a contract. Then there may be another obligation, you must pay the money in advance. If you don't do that, you can ask for specific performance. Therefore, you must be able to perform your obligation. That's why if the claimant cannot or will not perform his obligation, court will not grant equitable relief. Where a deed professes to make a general disposition of property for the benefit of the person named in it, such person cannot accept any benefit under instrument without at the same time conforming all its provisions and renouncing every rights inconsistent with them. Where a deed, there's a deed to make general disposition of property for a benefit of person. Now the deed or something given to you, according to the deed or agreement, you have to sell for the benefit of another person named there. Such person cannot accept a benefit under instrument without at the same time conforming all its provision. Then first of all, if you want to accept that one, you must accept all the obligation and you must be subject to the provisions of that contract. All other provisions. You can't take one provision there and sell the property and dispose it. That cannot be done. Once you accept the benefit, then you must accept everything. That's why here we say that deed professes to make a general disposition of property for the benefit of a person named in it. Such person cannot accept the benefit under instrument without at the same time conforming all its provisions and renouncing every rights inconsistent with them. If you have some interest in the property, you must renounce those interests. When you see this maxim focuses on future conduct. Future conduct. Now we will see the next slide here. Qualified voter was not allowed to vote. Voting rights given to somebody, then he is something qualified voter was not allowed to vote. Who sued returning officer, then he can file an action against the returning officer, because he must give some sort of, he must find the ways or means to vote there. That's why here we say that the government grant the voting rights to the people, then government must arrange or find the means by which he must be able to exercise that right. The plaintiff seeking an injunction will not succeed if he is unable to carry out his own future obligations. Then we will move here to other point, other next maxim. In that maxim, when you see here, he who comes to equity must come with the clean hands. It doesn't mean that you must wash your hands and come. While the previous maxim that we have seen now focuses upon the future conduct. If you come to the equity, then you must be able to do equity. That's something in future. But here, you must come with the clean hands. That means it is referring something past action. That's why while the previous maxim focuses upon the future conduct, this maxim concentrates upon the claimant's past actions. As equitable remedies are discretionary in nature, the claimant has to be deserving of equitable intervention. Hence, there will be no specific performance of a contract if the claimant himself is in breach, or if the claimant brought about the contract by misrepresentation or fraud. Therefore, if a person as a party to the contract, by way of misrepresentation or fraud, entered into the contract, and as a claimant, again the same person, asked the person now to enforce the contract, then really speaking, he was not in clean hands because he has committed a misrepresentation or fraud. Now he can't ask to enforce the contract. If it were otherwise, equity would be imposing a dual standard. For this purpose, it is the claimant's conduct that is to be examined and not the other party's behavior. Now here in this maxim, the claimant's conduct that is to be examined, because whether he has come with a clean hands. Accordingly, there is no balancing out of fault or bad behavior between the parties. You also done something bad, I also done something bad, then balancing there, then we will go for enforcement. No, that cannot be done. If a person committing a bad or committing a bad behavior, or he has some sort of bad behavior, or he has committed something wrong action, then he is not with clean hands. Then he can't ask for anything from equity. He can't expect anything. For example, if the landlord seeks to eject the tenant because of a breach of tenancy agreement, the court has jurisdiction to grant tenant relief from ejectment regardless of the landlord's conduct. The tenant will be denied intervention of equity if the past breach was found. Now this time the tenant fails to pay the rent. Then the court may consider those things and give some sort of relief. Maybe time frame or sometime delayed payment may be accepted. But earlier also there was a delay or there was a failure to pay the rent, then court will not come to or give the equity or equitable remedy. The lack of cleanness must relate to the dispute, not to unconnected matter. Then there's a dispute, then there must be something matters, then there must be a connection in between the dispute as well as the matters. If there are some matters not connected with the dispute, then you can't say that he has done something. Suppose now the rent matter, you say that whatever we have taken the example here, he has committed a theft somewhere else. You can't say that, you can't bring that one, and here you can't say that he was not in clean hands, because the matter should be related to the subject matter. Then here we will see further in the same maxim, for example, in Fiona Trust and Holding Corporation versus Rivalo case, the defendant pleaded that the claimant should not be granted equitable relief of any kind because of their misconduct in relation to the non-disclosure of documents and the improper carrying out of background investigation. In rejecting the defendant assertion, Andrew Smith J. made several points. First, the maxim is directed usually to conduct that is in some way immoral or deliberate. First thing, the maxim is directed usually to conduct that is in some way immoral or deliberate. Secondly, that not all the misconduct deprives a claimant of equitable relief, and that the conduct must be too trivial for it to have this effect. Thirdly, the court will assess the gravity and the effect of misconduct cumulatively, so that while the element of misconduct taken individually might be too trivial for the maxim to be applied, they must be sufficient taken together. On the facts before him, there was an insufficiently immediate relationship between the misconduct and the relief claimed. That's why we have said here earlier also, the lack of cleanness must relate to the dispute, not to the unconnected matters. This is again, we have whatever discussed in this one, it is here. Now we will move to the next maxim, where the equities are equal, the law prevails. This is not the big issue here. This maxim operates where there are two or more competing interests, one legal, other equitable. There are two, one legal and other competing interest. Then where the claims of both parties are fair and meritorious, the precedence will be given to the legal interest, because equities are equal, then law should prevail. The maxim was developed in connection with the interest in the land where the purchaser acquires the property bona fide without notice of defect of the vendor's title. The equities are equal, then the legal estate shall prevail. And also if the purchaser takes title with the notice of defect, the earlier title, if it is valid, then this also prevails. The force of this maxim has largely seen displaced by a registered system of land title registration. Now everything is here also in Sri Lanka. Every deed or every document in relation to the property should be done in writing, but here also it is not a mandatory requirement to be registered. Right, anyway, that we will study in your conveyancing in your final year. That's you will see later. Where two people are purported to purchase a good from fraudulent vendor for the same price, neither of them would have better claim to the goods in equity. Therefore, rules of commercial rules would be applied. Then we will see here where the equities are equal, the first in time prevails. For the purpose of remembering this maxim, just I would like to say something here. If a owner of the property or the land, today he sells the land to A and tomorrow he sells the land to B, then in that case, if B register the deed in first, then B will get the priority. That's the law in Sri Lanka. Here also, like, equities are equal, the first in time prevails. Who has registered first, then that will prevail. The time assumes importance to equity. In circumstances where two parties have equally strong cases, the party who acquired his equitable rights first will have the priority. For example, if two equitable mortgagees are competing for priority in order to determine who will have the first claim to the proceeds of the sale, then the eyes of the equity, the priority will lie with the mortgagee whose interest was created first. The maxim is the founding stone of the doctrine of notice, which prior to any system of registration regulated the priority between equitable interest in the land. Now what we are seeing here, this is a priority basis, we must decide this one. Then the same thing repeated here, just you can see here, I no need to explain this one. I move to other maxim, equity inputs. Equity inputs an intention to fulfill an obligation. If you do something, the intention must be the issue. This maxim means where a person is obliged to do something, but instead does something else, that could be regarded as a performance of obligation. Equity will regard this as fulfilling obligation. For example, where a debtor leaves a legacy by will to his creditor, the legacy will be viewed as the satisfaction of debts. Unless the presumption is rebutted, the creditor will not be able to both to sue on the debt and keep the legacy. That's a simple and very basic maxim. Then the case also given here. The husband agreed with the trustee to pay them 50,000 sterling pound for the purpose of purchasing a land in a particular area D. But he in fact never paid the sum but after marriage purchased the land at the place or area of D in his own name for 50,000 sterling pound. He died and could not bring the land into the settlement. Equity courts construed that he purchased the land to fulfill his obligation. That's very clear and simple. Now we will move to the next maxim. Equity regards as done that which ought to be done. In the situation where there is a specifically enforceable obligation, equity regards the parties as already being in the position which they would be in following the performance of the obligation. The maxim is well demonstrated in Wells versus Lonsdale case, where a 7-year lease was granted to the tenant, but no deed was executed. The fixed term lease was therefore equitable in the light that the specific performance of the contract to create a legal lease was avoidable. The court admitted that equitable lease is as good as legal lease. This was because equity looked on the lease as legal as soon as it was informally created. That's very clear example given here that you can see. The next one also clearly explained here. Then the fiduciary who took bribe became constructive trust. That also one of another example. If you get something as bribe, then the equity regards that you have done something, you are accountable, then you become a constructive trust of the bribe what you have received, right? Then we will have another case here. It was considered that the duty of insured person to hand over any damages from wrongdoer to the insurer was enforceable, so that insurer had immediate proprietary right in form of lien over the money. That's just a matter you can read and understand. And other one, equality is equity. That is, really speaking, I no need to explain because the very simple matter here. Equality is equity. You can say equality is equity or equity is equality. Either way you can say. Equity is equality is the maxim as regards the claims to the property under fixed trust. If the shares are not allocated between the claimant, equity presumes that each was intended to have an equal share. There is, really speaking, nothing to explain here, because even in the trust ordinance, there's a provision to the effect that there are so many beneficiaries, but the deed of trust is silent in relation to the distribution of beneficial interest among the beneficiaries. In that case, the trustee may give the beneficial interest equally to all the beneficiaries. That is equity. Right? That's very simple. Then is also another example given that you can read and understand. There is no big issue here. Then equity looks to the intent rather than form. Equity always looks the intent. What is the intention of the person, not the form. This principle here is that equity will look the substance and not be deceived by outward appearance of the transaction. Once again, the principle here is that equity will look to the substance but not be deceived by outward appearance of a transaction. This is evident in relation to the intention to create the trust, where it is not necessary that the word trust be used, and it is not conclusive even if the term is employed. Now, whether there's a term trust is used, whether there's some other term used, we don't care. We must see the intention of the party, whether there's the intention to create the trust. The court will look for the true relationship that was created. And the court will see the intention of the parties, whether they have some sort of intention to create the trust. That is the true intention. That's why we say that equity looks to the substance rather than form. Sometimes one may argue that there is no word or expression like trust. It doesn't matter, we must see the intention of the parties. That's why trust is created, with intention of his part to create the trust thereby. The purpose of the trust, beneficiary and trust property, these are the matters, must be clear. Where the author uses the words such as, I hope that you will keep the property for the benefit of somebody else, then trust is arising, trust is created. I request somebody to keep the property for the benefit of another person, then trust is created. Then these are the words, these are purgatory words, but still it creates trust. Then we will move here to another maxim, delay defeats equity. This is a further illustration of how the time is important to equity. Always time is important for law also, but here important to equity. It is often said that equity aids the vigilant and not the indolent. The rule is that if the court concludes that the claimant has allowed too much of time to elapse between the wrongdoing and the commencement of legal proceeding, equity will not protect claimant's rights. It is taught that the court decision will be based upon the notions of good conscience in the light of delay. You are really speaking, if you are really concerning about the violation or the equitable rights, then you must go to the court or chancellery court within the reasonable time. If there is a delay, the court might refuse to accept your case or maybe dismiss. For example, under English law, actions against the trustee breach of trust must be brought within 6 years. The delay short of this will no bar relieve. Under the trust ordinance, there is no such time bar in Sri Lanka. The plaintiff unreasonable delay is a weapon of defense by the defendant against the plaintiff. Then we should not delay the matter. We must go within the time frame, within the reasonable time to invoke the jurisdiction of the court. And here there's a claimant to rescission to rectification may be barred by delay. That's another reason, another best thing we must learn, that must not delayed. Now equity acts in persona. That I don't need to explain again and again. We have seen so many circumstances, we have seen this maxim. Equity as a jurisdiction of the defendant personally. As at the heart of equity, is the notion that it acts in persona. Equity acts in persona, which means that it is designed to prevent a specified individual from acting unconcernably. It strikes at the conduct and conscience of the defendant. This means that equitable remedies are personal in that they are exercised against specific persons. They compel or permit a person to do something or not to do something. For example, search orders and freezing injunctions. In relation to a breach of trust, beneficiaries' redress strikes against trustees personally. A failure to comply with the order of the specific performance or injunction is viewed as a contempt of court and punishable. It is also explained that why the equity can make an order relating to property situated outside the jurisdiction, because person within the jurisdiction, provided the defendant is within the jurisdiction. If the defendant is within the jurisdiction, then if the matter is in relation to the right in personam, then the court will have the jurisdiction to hear the matter. Thus, including leading case, that was a specific performance was ordered in an agreement relating the land boundaries in some other place, and also defended by that country, in that country, right? That we have seen. This is a simple example or the schedule here to see the difference between two maxims. Only two, not all the maxims. He who seeks equity must do equity. He who comes into equity must come with a clean hands. As I told you, the first one, you must do equity in the sense that a future actions, but the second one is something in relation to the past action. We have seen this one just to read and understand the differences and similarities between those two maxims. That is the end of the lectures on equity. Now we will conclude these lectures on equity. Then the next session or the next lecture we will start law of trust. Right? Thank you very much for watching these lectures.